Hi, I'm Greg Dell here with attorney Cesar Gavidia, and today we're going to talk about Lloyds of London. Now, Cesar, I know we've handled probably about 100 or so claims with Lloyds of London because, Lloyds of London isn't one of the bigger disability carriers. They tend
Right.
to write more of the specialty type policies, the excess policies above your traditional individual or group policies. But there's a lot of nuances that we see when we deal with the Lloyds of London policies. And one of the biggest ones, let's get right into it, is what do you see in these Lloyds of policies when somebody actually gets denied, the process that needs to be followed?
Yeah, it's a good question. So, like you mentioned, Greg, the Lloyd's policies or certain underwriters at Lloyd's of London policies are excess or surplus policies. So that means that once you reach a certain level of either disability coverage through other disability insurance, or you, for instance, have certain medical issues or something that are pre-existing that you couldn't obtain coverage through other disability insurance, but you want disability insurance, that's when you go to Lloyd's of London because they'll underwrite you for disability insurance. But what's different about Lloyd's is, like you said, they have kind of different procedures when it comes to disputing a claim or challenging a claim. So what they typically make you do is go through what's called a grievance procedure, and it starts with an informal grievance process where Lloyd's of London typically operates with a third-party administrator. It could be DMS or it could be another third-party administrator. And if you disagree with something they want to do or with the decision they made, so for instance, they want to send you to do an independent medical exam, but you don't think they're sending you to the right specialist, or you have some sort of conflict with who that IME is,
Right.
then you could say, well, I want to initiate the informal grievance process. And then they have to send that, basically your claim, to be independently reviewed by someone else. It could be in London or some other place that they perform the informal grievance process. And then once you go through that, there's a formal grievance process, and then potentially, depending on the policy, there could be an arbitration process, or you may be able to sue them if you continue disagreeing with their decision.
And one of the things I've been seeing lately in the Lloyds of London policies, which I think is disturbing, is that you go through the informal, you go through the formal, and then they say, okay, we're going to pick a doctor, and you pick a doctor to have it reviewed, and then we're going to pick an independent doctor.
Right.
And whatever, well, they say independent, or actually the two doctors decide who the doctor is going to be.
Right.
And then whatever that doctor says in terms of whether or not you're disabled, that's it.
Right.
There's no lawsuit after that. It's completely binding, and that's a little, to me, that's scary.
It is scary because we always look at it as, the claimant or the person who's being wronged deserves their day in court.
Right.
And these policies effectively bypass that. Now, on the one hand, you could say, well, it's more cost effective because litigation is expensive. As we know, lawsuits are expensive to pursue. But oftentimes, that's what needs to be done. There's a discovery process that goes on in the courts and all of that you may not necessarily have access to with a grievance process like that, like you're describing.
I just think we have this American justice system with jury trials, and people of the community are supposed to make a determination, or we have a judge that was either elected or appointed by people that we elected to appoint that judge. For federal judges, where a lot of these cases end up, and it's very scary to spend thousands and thousands of dollars for a disability contract.
Right.
To which Lloyd's is legally allowed to do this because you're buying a contract, you know what you're buying,
Right.
and then not have your opportunity to have this case reviewed by a judge or by a court.
Right.
But, point is if you're watching this to determine whether or not you should buy a Lloyd's policy, that's an issue to consider. However, if you've already bought it, it is what it is, and we're going to deal with it because we've seen every single scenario there is when it comes to a Lloyd's claim. Now, the other thing about Lloyd's is, like you said, Lloyd's is not this insurance company on their own where they have all their own staff evaluating these claims. There's multiple different third-party administrators that will administer a Lloyd's claim, and we've seen several of them because they don't always use the same one. And so, in terms of from a claims handling perspective, all of the rules in a Lloyd's policy that we use for all of our other policies basically apply. You got to get the appropriate medical support, you got to prove up your occupation, and you got to fill out the paperwork appropriately, otherwise you don't have a chance at all of really getting improved. But most of the claimants we see with Lloyd's are athletes or very high-level wage earners, and we see some unusual definitions of disability in these types of things. What are some of the unusual things you see in these Lloyd's policies that are inconsistent with what we usually see.
Right. So when you think of individual disability insurance coverage, you think of strictly own occupation disability coverage. In other words, the policy covers you if you become disabled from performing substantial material duties of a surgeon or dentist or physician. With these Lloyd's policies, they have definitions that resemble that, but then they can morph or they could change after a period of time. They could change to mean that you could either have to be disabled from performing your own occupation and not gainfully employed, or you have to be disabled from performing your own occupation and any occupation. So it could change because they don't have to necessarily follow the same guidelines and regulations that other individual disability insurance coverage has to, because again, they're not your typical disability insurance coverage. They're surplus coverage, so the same rules don't necessarily apply.
And, like I said, often they're big policies. I mean, I've had them as high as $50,000, $60,000 a month.
Right.
Professional athletes, if you mix, you got to be out permanently from a certain number of games. You have to be totally permanently disabled, meaning you can't play at all. There's a lot of little nuances that go on in every single one of these contracts, all of things that we've seen. And you've got to really make sure you understand what you're doing in order to get yourself paid on these policies.
And like you mentioned, usually the premiums are extraordinarily high because the coverage is usually pretty high. Like you said, you're covering high wage earners very often, people that have already received all the coverage, underwritten all the coverage that they could receive under typical individual coverage. And also it's for limited time frames. So you don't have coverage for lifetime, or you don't have coverage to 65. It's limited sometimes, usually to 5 years, and then it's over.
Right. So if you have a Lloyds of London policy that you purchased, feel free to give any of our attorneys a call. We will be happy to review the policy, review the status of your claim, and we'll let you know right away whether or not we can assist you.